Hello, everyone, and thank you for joining us for our program, Environmental Considerations when Acquiring or Permitting Utility-Scale Solar Projects in Virginia. My name is Brad Nowak. I'm partner and co-chair of the Renewable Energy Practice Group at Williams Mullen. I'm very pleased to be joined this morning by my colleague, Speaker Pollard. Speaker is a partner located in our Richmond office. He has over 3 decades of experience in environmental law and was formerly an enforcement specialist at the Virginia Department of Environmental Quality. Speaker is a member of our Environment and Natural Resources Practice Group, which has 14 attorneys located in our offices in Virginia, North Carolina, and South Carolina. Our team of environmental attorneys assist and help counsel renewable energy clients in environmental and regulatory issues at federal, state, and local levels. Before we kick off today's program, I have a few housekeeping items to go over. At any point during today's presentation, you may submit questions by using the Q&A button at the bottom of your screen. We will answer questions at the end of the presentation, time permitting. If you're having any audio or technical problems, please use the same Q&A button and someone will help get those resolved. Finally, you'll receive a copy of today's presentation materials by email later today. Today's program is part of our 5-part Solar and Energy Storage webinar series. Our first webinar of the series, Virginia Solar and Energy Storage 2022 Legislative Update, was held a few weeks ago. If you missed that program, it is available on our website on our Solar Resources page. We will have 3 more webinars in the coming weeks on a variety of topics. On May 5th, we have a program to discuss solar and energy storage tax and revenue share. We'll be addressing tax exemptions, how and when tax assessments are done and who does them, and what happens if a locality adopts a revenue share ordinance. Our state and local tax partner, Kyle Wingfield, will be covering that topic. On May 19th, we'll have a program to discuss energy storage permit by rule permitting. We'll be covering the storage PBR regulations issued by DEQ late last year. And I'll be joined by my energy partner, Bob Riley, for that webinar. And then finally, on June 2nd, our last webinar of the series will be on solar and energy storage siting agreements and land use. We'll be covering the details of siting agreements and their interplay with local permitting. My land use partner, Steve Revine, will be presenting that program. The email that you will receive this afternoon will actually include a link so you can register for these upcoming webinars. Now let me pass the program to the speaker who will kick us off by providing a roadmap of today's program and begin with his presentation. Speaker?
Thanks, Brad. Appreciate the introduction. Welcome everybody to today's webinar. Really excited to cover this information for you and with you. We have a lot to cover. Don't have too many bullet points there, but there's a lot in each one. So let's jump into it and move to the first item, but we're going to have cover a lot of ground, as you can tell. So the first item we want to talk about, which is probably on everybody's mind if you've been in the loop of the last week or 10 days or so, is Virginia's DEQ new stormwater policy addressing solar panel imperviousness. This was a policy memo that was issued on March 29th. It had an immediately effective date, went effective right away. The substance of the policy change was that DEQ will now, basically as of that date, treat solar panels as impervious surfaces for purposes of post-development stormwater management planning and controls that are needed on site. In the past, or up to that point, DEQ had treated them as not as impervious per se, and so this is a significant change. And so to unpack that a little bit more, the memo does say that from a water quantity perspective, addressing stormwater management, DEQ will view the panels as unconnected impervious areas when performing post-development water quantity calculations using the VSMP hydrologic methods set by the regulation. So they are recognizing that it is not one uniform, solid, across the board surface, that they are unconnected. However, some preliminary indications suggest from engineers that we've talked to is that is that the difference between considering it as connected or unconnected may not really add that much value, if you will, for or give much of a break in terms of how impervious these things would be treated. The next aspect of this was water quality calculations. Again, different from water quantity, or different kind of set of calculations and standards. In that sense, the DEQ would view the panels as impervious surface areas when performing the post-development water quality calculations using the VRM, the Virginia Runoff Reduction Method. So that's how that would be addressed as part of the water quality calculation. It's interesting because, and a little alarming, frankly, in that on its face, the policy memo does not seem to contemplate the fact that vegetation underneath the panels and around the panels, but certainly underneath them or between them, between the panel rows, has much, if any, offsetting value in terms, to offset the panel surface imperviousness, if you will. And this, of course, raised a lot of alarms because, it doesn't seem to account for probably what's really happening literally on the ground as the rainfall drops off of the panels and hits usually what is a pasture or maybe, low growth turf vegetation underneath in most cases. So the memo also states that staff implementation guidance would be forthcoming, but the scope and the timing of that new of that guidance is not set out in the policy memo, and it's left just sort of hanging out there in that regard. So the policy memo makes this material change, significant change in how solar panels will be addressed for stormwater management, but doesn't really offer a lot of details about how this would be done. Now, one thing to consider here is sort of which projects does this apply to, and it has an immediate effect, but there is some further detail as to how this would apply. And basically, the memo says that all solar energy projects for which stormwater management plans had not been approved by the VSMP authority, that is to say DEQ or the authorized VSMP locality, before March 29th, are going to be subject to this guidance or this new policy change. So conversely, if you've had your stormwater management plan approved on or before March 28th, then this new policy would not apply. So for those projects that have not gotten to that point, have not had a stormwater management plan approved before March 29th, this policy change does affect you regardless of the state of the planning or development of the project. So you may have all of your site control, all of your options in place, your land use approval from the locality, everything is, all these things have been done. You've maybe even got your you've got your application into PJM for your interconnection, and sort of, that's been sitting there. But if you don't have your stormwater management plan approved before that date, then this new policy takes effect, or would be effective for you. There's no other grandfathering or kind of delayed effectiveness in some concept really contemplated by the policy memo. So again, if you don't have even if you have some of these other approvals in hand, it doesn't seem to matter. The real key is whether your stormwater management plan has been approved. So next slide. So what was the rationale? Why do this? It's not really set out very clearly in the policy memo, but it appears to be with some sort of oblique reference to it seems to be based on concern with consistency with the Chesapeake Bay program modeling of stormwater runoff for solar projects when they're trying to track compliance with the EPA, the Chesapeake Bay total maximum daily load rule that was issued a number of years ago, and for which we're in sort of third phase of watershed implementation planning to meet the rule deadlines. The ultimate deadline is 2025. And for those of you who may not be familiar, the Chesapeake Bay TMDL rule is basically there to establish hard deadlines and hard finish points for reduction of nutrients and sediment loading into the Chesapeake Bay watershed, streams and rivers and the bay itself. There's a modeling program that the Chesapeake Bay program uses to assess what the impacts have been over time for various other controls that have been put in place, best management practices, and just otherwise what's happening in the loading, the nutrient loading and sediment loading into the bay. And the recent Chesapeake Bay, one of the things that, wow, this seems to be tied into this, is that the Chesapeake Bay program TMDL modeling land use classification guidance, a recent version of that, incorporated solar projects, but it does account for vegetative cover types. So there seems to be this kind of interesting, I won't say disconnect, but sort of lack of congruence in some respects between what the policy says or doesn't say on its face, and maybe where the ultimate or the background guidance from this land use classification guidance from the TMDL may actually account for vegetative cover. So again, there's just a lot of uncertainty there. There's a lot of, lack of clarity as to how this would work. And so the impact from this is obviously pretty concerning for solar development projects, particularly those that are well on their way or have already had significant investment. And the impacts would be project specific, but certainly you could anticipate project delay and increased costs at minimum. And for one thing, there would be a disruption to your stormwater management facility planning and the development of the stormwater management plans that you have to have based on sort of readjusting how the panels are going to be counted toward the stormwater load, if you will, from that facility, now that they're being treated as impervious. The other key concern is in connection with that, and these things are all sort of related to each other, is whether there would be a additional need for area on site to handle additional stormwater management needs based on what you would have as increased quantity or quality control needs, whether you need additional land within the project area to do that, or whether you might have to use off-site stormwater management areas that you would have to put under basically a conservation easement, in a sense, to offset that increased stormwater load. Obviously, if you have to dedicate more of the project area to do stormwater management, you probably are going to lose area that you can put toward the actual solar panels, and therefore lose potential solar generation capacity for the project. And that in turn has impacts on the project value proposition and even the PJM application that may have already been filed that's assuming a certain level of generation at that point. I think the other problem we're going to have, or we could expect from this, is a delay in getting the plan approved, the stormwater management plan approved, because you have to go through that process of redoing the calculations and site engineering in probably many cases and then resubmit the stormwater management plan that you or redo it from where you thought you were going already, and to have that teed up for DEQ to get approved without a lot of guidance at this point. It's hard to know exactly how staff is going to review that and assess that that re-engineering and redo of the calculations. And then, of course, that also begs the question of whether your stormwater management plan will have to be redone to account for additional offsite management areas as well to offset what you can't do on the site due to this potential increased stormwater load. The response from solar development industry in particular, but other key solar industry partners, has been immediate and broad, and with the significant concerns raised and really sort of pushback, if you will, on the policy memo itself, with all of the concerns that I've just mentioned, as well as just the potentially massive impact on the economic investment that has been made in solar projects, generally those that are already underway, and certainly those to come, and whether it could really dampen the prospects of doing solar projects in Virginia by making it that much harder to gain the sufficient land area you need if you have that much more stormwater management to do on site. So where do we stand now? Where do we stand now? Well, that's a good question. There has been, in response to a number of meetings that have been had with DEQ management and even sort of up further into the governor's office, we sense at this point that there is a potential for changes to this policy. We don't know exactly what that's going to look like, and we are waiting to see what DEQ's next steps will be. I think that it's fair to say that DEQ management and the governor's office and the secretary's office have received the message loud and clear of the concerns, and I think that they are. It seems as if they are trying to evaluate options for how to address these concerns, but we don't know exactly how that's going to shake out. We don't know whether, for instance, there would be some sort of phased implementation, what the timing of that would be. We're waiting to hear is the bottom line. And of course, when we hear, we will let you know as soon as possible. And many of the folks in this audience, I know, are actively involved in this issue already. So the next item we want to move to is the Virginia Department of Wildlife Resources new solar energy facility guidance. This was issued February 10th. And you can see in the slides, there's a link to that, which you'll have. And this sort of treats, sort of has 3 or 4 main sections to it about how to deal with wildlife resources and assessing the impacts of solar projects on wildlife resources in connection with the permit by rule process, but other reviews, perhaps, if it goes to the SCC for review instead of going through the DEQ permit by rule process. So the first aspect of the guidance does deal with PBR, permit by rule, and addresses sort of what the expectations are of Virginia Department of Wildlife Resources when they do their review of the PBR application and package that you would submit. And it outlines a number of things that they are going to be looking for in that summary report and the operations and mitigation plan that is typically part of the package that you would submit with the PBR application. So you see initial project assessment, really just some of that's driven by regulation. The bald eagle nest presence absence, and they have a particular place to go to on the mapping, if you will, that would help in that. Bats and bat habitat evaluation, that's nothing new to many folks. And you can see the resources there that they cite. And then coastal aviation protection zones. So these are things that are not unfamiliar with folks already, but the guidance does provide a little bit clearer sense of what they're looking for in that regard. Next slide, please. The next item in the guidance is dealing with wildlife passage and fencing issues. And here I think they are providing some additional helpful guidance and again, addressing expectations for what they hope to see in these packages. Documenting and an assessment of wildlife travel corridors that would go through the project area, and coordinating with wildlife resources folks on wildlife, potential fencing and design practices to facilitate ingress and egress of various wildlife species. There's also fencing heights and configurations for deer passage that are recommended. And then the hunting prohibition within the fenced area is also expected. So statements to these effects, is something they're going to be looking for that. Vegetation management, again, they're looking for native species and seed mixes and invasive species control. Some of the other considerations that they identify that may need to be addressed in these, or that they will take up, is a potential lake effect issue. This is still something that's I think is really still a matter of study in some ways, but they are considering whether waterfowl may mistake the panel arrays for water features, and whether some sort of monitoring of that issue might be needed for the project, at least for a period of time. Thermal island effect is another concern that has been raised, at least in some quarters. Again, this is something that they're I think the agency's trying to get their arms around. Is this really an issue or not? And again, maybe some monitoring duties might be expected there. And then looking again, just stream and wetland impacts, they have the role as part of that interagency consultation for wetland permitting, and just want to make sure that everybody's aware of that. Next slide. Now they do have some standard site development recommendations that can be that ought to be considered here. Some of these again are not going to be new to folks. Avoiding and minimizing impacts to forests in their sort of natural state and wetlands and streams. Trying to maintain those undisturbed natural buffers around wetlands and streams, maintaining wooded lots. They definitely, they're pretty clear about they don't recommend, and they are arguably discouraging wetland mitigation impacts through construction of stormwater management ponds or creation of in-stream stormwater management ponds. Of course, that dovetails back to the stormwater management regulations themselves. Thinking about project stormwater controls, they really want to try to keep those in line with the natural terrain and hydrographic condition of the site, and thinking about using low impact development practices to achieve that. They have time of year restrictions mentioned, again, not necessarily new to folks, but for time of year restrictions for tree removal and ground clearing, and then making sure folks are sticking with their erosion sediment control plans during the actual construction work. Next slide. So let's move on to stormwater management conveyance issues generally. I think everybody who is in the stormwater arena, whether you're in solar or other industries, and you're seeking permits and plan reviews for construction activities, you know that there can be significant delays in the review of the stormwater management plan, or at least getting to approval. And whether that's because it's taking a long time to get the initial review done, or there's back and forth with comments that seem to raise issues that, not really sure where they're coming from, and then you have cycles of reviews. DEQ, I think, certainly under the new management here, the new administration seems to recognize that there is a problem here, and DEQ is considering options to alleviate the delays in getting stormwater permitting done. And I put a link in here to an article that came out this morning that is based on a presentation made yesterday's Virginia Chamber of Commerce sort of sustainability summit, where Mike Rolban, the director of DEQ, mentioned some actions that they're looking at to address delays and speed up the process and give greater certainty in the process. One of the other key considerations here is outfall locations and the rights to use neighboring property for flow to reach or impact stormwater conveyance systems. This has become a more of an issue, particularly in I would say, just recently, as I think DEQ has certainly taken a closer look at outfall locations and whether the conveyance that sort of required stormwater conveyance system by the regulation is right there at the on the property or at the property boundary where the outfall may occur. If not, then conveying stormwater across somebody's property to get to that conveyance system or to address potential flooding or other impacts to that conveyance system is something that DEQ seems to be really pressing right now. So what we're seeing is potential need to consider whether or not stormwater easements on neighboring property owners, that is to say, those that are not owned or controlled by the in the project area itself, may need to, whether those easements may be needed to connect the dots from the outfall on site to the proper, the qualifying stormwater conveyance system that may exist off-site. Some of the tips to consider here is just making sure your plans, stormwater management plans, include all the required elements and guidance, making sure the quantity calculations demonstrate that you don't have downstream adverse impacts that, associated with flow in particular. Making sure you're checking the boxes on the VRM protocols for water quality calculations, and that you're achieving the site management, on-site management of stormwater as much as possible. Again, demonstrating that the use of the off-site areas to offset nutrient loads is necessary. You have to check the box there, and don't cut stormwater management too closely to the edge of the need. That is to say, leave some wiggle room in there, because a lot of times these plans change or evolve a little bit, and you want to have a little bit of buffer, so to speak, in your planning to account for potential changes or increases in your loads that you may have to address. And if you've got a little bit of elbow room in your stormwater management capacities, then you don't have to go back and revisit your design. And then again, all this is a lot of balancing between stormwater management on-site, the space you need for stormwater management, versus generation capacity space, and trying to find the right balance. Next slide. So let's talk real quickly about option purchase agreement. Looking at acquiring property or gaining control of property, or buying a project that may be already partially in development, and looking at environmental reps and warranties. A lot of that's going to depend on the nature and the extent of the planning of the project that's already in place at the time of the transaction. How much seller due diligence has been done, when will the buyer due diligence get done, trying to figure out sort of how much information you already have and how much you still need to get as to what level of representation and warranties may be appropriate. One of the key issues is hazardous materials being present on the site. This can obviously affect project development viability, or add to costs if you have to do some sort of remediation or management on site, or limiting your development potential for the site. The risk for stormwater management for this is also there with runoff of contaminated compounds or contamination from the site. And this comes up in particular for formal industrial, commercial, and mining uses, where you may have contaminants that are in the ground that could be disturbed during the development of the site, or may come in your stormwater management later on, even if you don't have to do remediation. A lot of folks are thinking about solar development on landfills. That is another, presents its own issues in terms of hazardous materials and stormwater management from those. Even raw land has an issue with, present issues. Former farmlands or orchard lands or wooded areas have their own risks, as you can see there. And obviously you want to manage your potential Superfund liability, coordinating your reps and warranties with the timing and scope of your phase 1 due diligence. And I'll talk about that in just a second. Site and prior use environmental regulatory permitting compliance is also a key factor, making sure you've got coverage there to know that there's no outstanding environmental regulatory compliance problems. Are there any third-party environmental claims or liens? And seller knowledge qualifiers are also can be a factor in how you develop these environmental reps and warranties. How much the seller will be willing to qualify in that regard, or would want to qualify, and how much the buyer is willing to allow that qualification to exist. So those are all factors. Next slide. So from doing your phase 1 environmental site assessment, your initial due diligence, the phase 1s, most folks I think are probably familiar with phase 1 as sort of, something you want to do to kind of get general knowledge about the site, but it's also your hedge against Superfund liability and being eligible for innocent landowner defenses under the federal Superfund law and EPA regulation. So in that regard, you've got to meet your all appropriate inquiry standard and your all appropriate care standard that are set out in the regulation to ensure you have those defenses. Now, the phase 1 environmental site assessment standard set by the ASTM just changed. EPA just adopted it with some transitional language there. You can see the links to those, some information for, further information about that. But you also need to be mindful of, protecting that eligibility, generally as you go forward, obviously following the ASTM and the all appropriate inquiry standards. Keep that phase 1 report current as to all of its elements per the ASTM standard. Watch out for expiring elements of the report. Some elements of the report expire sooner than others. And make sure the report is issued to the actual project entity, the project entity that's actually acquiring the property interest, whether it's the owner or a tenant. A lot of times, you start off with one entity and you end up with another. And if phase 1 is issued to the wrong entity, it doesn't do any good. So some basic due diligence tips here. Make sure your consultants have the expertise and capacity to really address the project you need. And I know this sounds a little self-serving, but engage your attorneys early on to spot issues and help plan and coordinate legal needs. That will save time in the long run. Determine early on where your wetlands and streams are and what your need for on-site or off-site stormwater management areas and easements may be. Those permitting processes are often the longest in the project lifespan, longest pole in the tent. All right, next slide. I think we're kind of rushed through, I know, a lot of these things, I think we're basically at the end of our time. I know we've got some items in the Q&A, and we can certainly respond to those afterwards. Brad, any further thoughts, comments?
No, I appreciate it, Speaker, and thank you everybody for attending today's program. If you've got any questions or would like to be added to our mailing list, feel free to email us at solar@williamsmullen.com. And thank you again for attending, and we hope to see you at our next solar webinar on May 5th.
Thank you, everybody.